A revolutionary journey is underway, one that would see the island becoming the first within CARICOM to hold a referendum solely on replacing the London-based Privy Council with the Caribbean Court of Justice as its final appeal court.
We should have been part of this court perhaps within the first year of its establishment. The Caribbean Court of Justice has been established for 10 years now. And I think it's untenable for us to continue to literally beg accommodation from the Privy Council. In fact, they have already indicated to us their unwillingness to continue to accommodate us. So before we are pushed unceremoniously, I think that we ought to do the prideful thing and to move to the CCJ. I believe our people are prideful people, and we'd want to know that we are presiding over our own sovereignty. In fact, I think that by becoming a member of the CCJ, to be part of a court in which we have ownership, that this is all part of completing the cycle of independence.
In 2005, Antigua and Barbuda ratified the agreement establishing the court, but could not adopt the CCJ in its appellate jurisdiction due to the constitutional requirement for a referendum. The government is now moving ahead with this process.
In Antigua and Barbuda, we are of the very firm opinion that in order to be independent, we must be truly independent in every sense of the word. And adopting the CCJ as our final appellate court is one step towards achieving full independence in the region. I cannot for the life of me understand why persons are still resistant to the CCJ. For many years now, the Privy Council has been expressing in his opinion and decisions the need to get away from the Privy Council and to get our own jurisdiction. That is what we are doing at the moment. Under our Constitution, because it's entrenched, we must go to a referendum to have that done.
It is important for us as a people to be able to make important decisions at that level and for us to be able to shape the kind of Caribbean that we envisage as a people. And so to that extent, I am fully in favor of our going forward.
Dominica and St. Lucia, and I believe St. Kitts, because of their constitutional provision, can go by way of agreement. And it's really a matter then for the Parliament in England to accept. And you see the differences. We all have independent constitutions, and all our constitutions are not identical. With us, we have to go to referendum. I think it is important that all political parties within Antigua and Barbuda join hands in respect of that referendum. It must not be looked upon as a matter for political convenience or to gain political points. We are going above and beyond that.
The Antigua and Barbuda Reparations Support Commission is not standing on the sidelines on this issue. Chairman Dobrino Mad says it's important that those who dispense justice understand the culture of the society.
We are still involved in an anti-colonial, pro-independence movement. And the break with the Privy Council we see as extremely important and very, not only symbolic, but important in the lives of the Caribbean people to continue this break with colonial rule and colonial domination into this our independence era. And so this idea, this crisis of confidence, that is the term they use, those who wish to delay this process. I'm just suggesting that this crisis of confidence, I think, should be met with those facts, should be met with the knowledge that it is not everything our political leaders do have ulterior motives and bad-mindedness, that they are processes that have been well conducted. And when we see them, we must salute them.
To help prepare citizens, a national coordinating committee was established. With participation from a wide cross-section of groups, the NCC is spearheading a comprehensive public education and sensitization campaign.
Antigua and Barbuda, in order for it to join the CCJ at its appellate jurisdiction, must have a two-thirds majority on the day of a referendum with respect to votes cast on that day. And so a national coordinating committee was established. We have several stakeholders, and we have been meeting at least twice so far. We have had good participation in the discussions.
We do hold a key role in society where, one, we understand the legal issues where the ordinary person would not. That person will be looking to us to see what our view is on it, and we cannot take an impartial approach, in my view, towards this move. We have to be able to, we can't just put the information out there simply and say that, well, John Doe, you decide. We have to be able to say, look, this is a good move because of XYZ. This is not a good move because of ABC. We think that is important as a bar. And we ourselves are moving towards getting a position, so that we can say to the public, look, we support the move or we do not support the move. But of course, that comes after we ourselves have educated ourselves on the issue.
There are two components to the CCJ. We have been hearing a lot about the appellant. There's the other aspect of it in terms of the original jurisdiction, which deals with the whole question of trade, right? And I think from a business perspective, that is important. As we look at the CARICOM and the OEC as the freedom of movement, then in time we will have interface with respect to business, different countries. And so how do we settle these challenges and these disputes? And we see it as part of the whole process of business. And so we think it's important as a chamber to be part of this discussion so we can move the process forward. And such as a nation, we can come to a decision one way or the other, based, as I said, based on information, based on facts, based on the whole question of our whole national development.
I would see our movement towards the Caribbean Court of Justice as part and parcel of our movement towards full independence. I see it in the same realm as the necessity for other constitutional changes. For example, the whole question of abolition of the monarchy as head of state and movement towards republican status. I see it in the same context. And I think that many times some of the, anti-CCJ sentiments that are expressed seem to cast some sort of doubt on the efficiency, integrity even, of our own judicial practitioners. And I think that this is particularly disturbing in the sense of not recognizing our own and not realizing that in many cases in jurisprudence in the Caribbean there have been many jurors and judges, etc., who have reached to quite a high level of respect internationally.
As in the case of other CARICOM member states, some Antiguans and Barbudans harbor reservations about the regional court, mostly stemming from fear of political interference and otherwise.
We need to find out where the judges are coming from, what are the intention, and we don't like how the Caribbean is running. So we are staying with the Privy Council.
They should, if you don't have any government interference, they should, if the government not interfering with the procedure.
Whatever they want to do, they's in charge. They do what they want to do. It don't have nothing to do with me.
The right thing still, that's my idea. I feel like the right for us join on. Definitely.
If the situation is of equivalence to the said court in England, and we can do it in the Caribbean, I mean, I think it's fair enough that we can go along with it.
As far as me concerned, the whole justice system is a co-op system. Because anything you do right now, and they do, justice is not for the poor people, it's for the rich.
Well, I have a lot of concerns, and I join the CCJ. Meaning that.
Many have been influenced by the legal battle between Observer Publications Limited and the government when the media company was refused a broadcast license in 1999, even after going to the local court of appeal. Observer was forced to take its case to the Privy Council, where the ruling was overturned.
The Observer media situations, we had to go to England to get justice, and we wouldn't get it here. But that has no logic. How can you say that? Tell me, how can you say that if there was a CCJ at the time, you would not have won? Black people just can't accept that there are good things that we do.
Well-known businessman George Ryan is firmly against the CCJ, basing his decision on past experience. He too went to London to challenge a lower court ruling and won.
They're under work at the moment because of the confidence. People from Antigua, St. Kitts and Nevis and all around are still going to the Privy Council. Why are we not? Because we're in the region, it's going to cost us less and so on. Why are we not gravitating? Because we have been burnt, and burnt heavily. You understand? When I went to the Privy Council, none of the judges knew me. And they look at the matter that was before them. And this is what they were litigating. This is what they were ruling on. The facts of the matter, not who you know. And what family you're from. And what education you might have. Or which one of the university you attended. Or where we were fellows in this particular school.
Businesswoman Makeda Mikkel had a similar experience to Ryan, but unlike him, she's firmly on the side of the CCJ.
I had to fight the government and the Stanford Development Company, both of whom employed about 80% of the population in Antigua.
Despite taking her battle to the Privy Council and winning, the aviation expert is not convinced the London-based tribunal should be the final court of appeal in the region.
Having to seek justice in the UK is a foreign luxury which most of my people in this region cannot afford. I had to work very hard over a very long period to accumulate the kind of money that was necessary to fight my cases in the Caribbean and then to fight it in England. Even though I was very happy with the outcome, in that the Privy Council took very little time in seeing how wronged I was by both government and the Stanford Development Company, I felt insulted that I had to go to them for my justice because they had left such an antiquated system in my part of the world so that I could not get justice in the Caribbean. And that is why I welcome the CCJ, even though I do feel that we have a responsibility to make England pay for our courts.
Dr. Henry says it's important that the committee gets its message to every citizen and that each one is fully apprised of the facts on the CCJ.
The public education campaign will seek to address a number of fallacies. People believe that there will be manipulation by the politicians. People believe that our judges may not be at the same high quality educational standard as those at the Privy Council. These are pure fallacies. Our justices are international renowned, and they can stand shoulder to shoulder with any across the world, including those at the Privy Council. In fact, several of our justices in the past have served on the same Privy Council.
Sir Gerald Watt, a Queen's Counsel with over 50 years' experience, also harbored reservations. He'd agreed in principle with the CCJ, but was concerned that not enough money was being spent at the level of the lower courts. Sir Gerald has since been fully converted and is now a strong proponent of the Trinidad-based court.
Once the decision had been taken, I had to rethink my position, because then it didn't mean that because you had problems down there that you hadn't solved yet. It didn't mean that it was time to bring Caribbean justice, the last Court of Appeal, into the Caribbean. It was high time. And then again, I began to really be appalled at the position taken by certain institutions. Because I thought that, look, once you got even an idea and you listened to how the court was set up, how it was financed, and the judges that staffed it, what their resumes were, you would have to decide that that was a quality court.
But how accessible is the Privy Council to the ordinary man? Only 15 cases have been filed by Antiguans and Barbudans in the past 9 years, a situation experts link to the costly nature of the exercise. They say going the route of the CCJ would be far cheaper.
Most of those matters that go to the Privy Council are matters are constitutional matters where government has overstepped its bounds, and matters in criminal cases, particularly in respect of the conviction of murder. And in respect of the latter, it's legal aid which has assisted those prisoners to follow up with their matters. And you know, in England, constitutional issues are very, very important. And in respect of governments, it's really individuals, for example, the Observer Radio, the HMB holdings in respect of the acquisition. These are the persons who find themselves there because it is expensive.
You know why it's very few? You can't afford it. The cost of a Privy Council to go and win your case, initially you have to put your hands on between 150,000 and 250,000 EC dollars and more. If it's a very serious case with a lot of documentation, it could reach 350,000. And you hear these wonderful people calling into the radio, but we have to keep the Privy Council, and poor things, they can never reach here.
The country's regional neighbors have been paying keen attention to these latest developments. Among them are Belize and Barbados, where ascension to the CCJ was achieved through a vote in Parliament. The constitution of those two countries makes no provision for a referendum, and the leaders say they have no regrets about taking that decisive step.
My government has been before the court in adversarial matters with other parties, and the court has, more often than not, ruled against us. But we have accepted those decisions as being the correct ones. So, two things. The fact that I am the lead head of government having to do with the court has not gotten us any favors at all in terms of our litigation before the court. And number two, even though we have been on the losing end of some of those decisions. We have respected the quality of those decisions, both with respect to judicial research and judicial intellect, but as well with respect to judicial integrity.
It starts with having confidence in yourself, having respect for yourself, having a belief in the integrity of what you are capable of creating. And once we get people to that level of understanding that they're not inferior to anybody, that what they create is not inferior to what is created elsewhere, I think the move towards the indigenization of our jurisprudence will happen. So I'm very pleased that Antigua and Barbuda is embarked on this crusade come March. I think it is a forward-looking step. And what better country to do this than Antigua and Barbuda? Antigua and Barbuda having been there at the beginning of CARIFTA in 1965, when the CARIFTA agreement was signed at Dickinson Bay in Antigua. So with Barbados and Guyana having gone ahead, we are missing Antigua. And Antigua must take its rightful place in this Caribbean Court of Justice queue.
In the case of Barbados, you have the Shanique Myrie case, and the CCJ interpreted the CARICOM Treaty, in which they indicated that all nationals of CARICOM, they have the right for at least 6 months stay within the member states of CARICOM. And there was even an award for cost and damages. I think the government of Belize, they also had a case that they lost at the level of the CCJ. And it has shown very clearly that there's no political interference and that even governments have actually lost cases so far.
The Supervisor of Elections is constitutionally responsible for the conduct of the referendum. Lorna Simon, who holds that post, explains the way forward.
What we plan to do is to employ the same persons who were used during the general elections. So you have a cadre of persons already in place. Once they are provided, they are available, and they will be used on the day of the referendum. Instead of having the names of candidates, you will have a question. And so based on how the rules are drafted, part of our education program will be to inform persons that you look for a question with a yes or no answer. And I made some suggestions that just as on our ballot, there's a symbol that for persons who maybe have problems reading, they could use symbols. So a symbol representing yes and a symbol representing no.
The supervisor works in tandem with the Antigua and Barbuda Electoral Commission, on which Nathaniel Paddy James serves as chairman.
Every June and every December, a final list of electors are published, and that is the official list of electors. But if there is an election, that official list is not what we use, because we can make adjustment. Person may have died, we can clean up the list, and we will do what is called, we will issue what is called a list for election. And it's on that list. If your name does not appear on that list for election, you can't vote.
James says the commission will play its part in informing residents of what would be required while remaining impartial throughout the process.
Our job is merely to prepare people to vote for whatever, yea or nay, because people have a right to say yes or to say no. And so we're not going to become involved in that aspect. And so it must be clearly understood that there are two segments to this process: the political segment and the electoral jurisprudence aspect in terms of the law and how we behave and conduct an election. It's going to be similar to what is expected of us to take a middle ground and not to become adversarial on one thing or the other. So we're not going to become involved in that.
In the meantime, residents are being urged to complete the circle of independence by taking control of their judicial future and saying yes to the Caribbean Court of Justice when the referendum is held.
I think we're lucky here in Antigua and Barbuda in that we now have an agreement with the opposition in which they have joined us to depoliticize the issue of having the CCJ as our final appellate court. And that is definitely a good start, and I just hope that that level of maturity will continue going into the referendum. We have indicated already that if it becomes an issue of partisan politics, then clearly my government will not proceed, because this issue cannot become mired in politics. What we're seeking here to do is to complete that cycle of independence, to make sure that we could preside over our own jurisprudence.
Do what is right. We want to be independent. We are economically independent, and we're on the way of getting other matters, freedom of movement, etc. in our region. It is only right and proper that we adopt the CCJ as the final court of appeal. We have persons who understand our society, persons who live here. We must develop something that's autochthonous, something that's homegrown.
It spans across borders, across the community, and we are hoping that after Antigua and Barbuda would have done its work, that others in the community that have not signed on to the appellate jurisdiction of the CCJ will see that it is time for them to join the movement.
When one looks at the situation, one must appreciate the reservations that the people would have because of a historical situation. At the same time, the historical situation also on the other side of the coin suggests that as a people, we must be able to develop the confidence and the decision-making mechanisms that will shape our destiny as a people in this region.
Before I retire, I want to go and appear before the CCJ on an important matter before I leave practice and or die.